Hello and welcome. Now, today I'm going to take a look at the new Employment Rights Act and what actions you can take before April of 2026. And some of the main changes are going to start to be made. Now, let's go back a wee bit. The Employment Rights Bill was introduced to Parliament in October 2024 as a key manifesto pledge by the Labour government. The bill went through all the usual stages in the Commons and Lords, as shown on the screen, until it got to the final stages. It was more or less plain sailing until that point. In the final stages, it spent weeks in a back and forth between both houses before the bill finally achieving royal assent on the 18th of December 2025. So this means we now have the Employment Rights Act 2025 to get our heads around and put changes in place. Now, originally proposed as day one unfair dismissal, there was a lot of debate and back and forth between both houses on this, amongst other things, but one of this particular. The government had proposed an initial period of employment, which was going to be 6 months, I heard 9 months as well, and the House of Lords pushed back on this. Now, the confirmed change of unfair dismissal after 6 months is, in my view, a pragmatic approach and hopefully one which will be easier to administer as well as understand for everyone concerned. Now, upon confirming the 6 months and getting the bill across the final piece, the government announced plans to lift the current compensation cap that applies to unfair dismissal claims, which is a year's gross pay or £118,223, whichever is lower. The government instead opted to remove that cap altogether, and frankly, the average case is less than that anyway. Now, what does this mean? Well, protection against discrimination and whistleblowing will stay as day one rights. That doesn't change. The implementation date for unfair dismissal qualifying period of 6 months is yet to be confirmed, so we don't know when it's going to be from. However, what we do know is it was originally scheduled for introduction in 2027, so we wait the exact date with interest. Now, beware that the reduced qualifying period may well include existing employees, so something to be aware of. The unfair dismissal compensation cap removal is subject to a pre-commencement impact assessment, although that might not result in any changes being made, particularly given where we are, and that business leaders, including the CBI and the CIPD, were really keen for Parliament to just get the bill over the line. It had gone on long enough. Now, in terms of what you can do, we'll certainly get prepared and just look at what will change and when, know that timeline. Certainly review your probation procedures to make sure they're working effectively. And if you don't have probation periods in your business, now is likely the time to introduce it so you will get used to it. Definitely ensure your managers understand their responsibilities in this process and are applying your processes correctly. Now, in terms of the Employment Rights Act, we'll be bringing you more details on the new Act as we move forward. But if you're looking for help with anything I've mentioned today or anything else in relation to employment law, why not contact your local HR expert? You can use a QR code on the screen to find yours. And thank you. I'll see you next time.